welcome to the Institute for Global Engagement's Faith and International Affairs conference call series. My name is Rob Joustra, an editorial fellow with the Review of Faith and International Affairs at IGE, and I will be serving as the moderator on today's call. I'd like to extend a special thank you to all of our callers who've dialed in to discuss the topic of public order and public morality, uses and abuses of the legal limits on free speech and religious liberty. I hope that you will all enjoy and take part in today's discussion. I'd also like to welcome our distinguished speaker for today's call, Asma Uddin. Thank you, Asma, for joining us today and sharing some of your insights and expertise on public order, public morality, and freedom of speech. Ms. Uddin is counsel at the Beckett Fund for Religious Liberty, where she joined in 2008 after practicing commercial litigation at prestigious national law firms for several years. She is a 2005 graduate of the University of Chicago Law School, where she was a member of the University of Chicago Law Review. Ms. Uddin spent her first 2 years at the Beckett Fund serving as the primary attorney for the Beckett's Legal Training Institute, which is devoted to working with local partners around the world to train advocates, lawyers, judges, religious leaders, journalists, and students in religious freedom law and principles. More recently, she's taken on the role of legal counsel, defending religious liberty in the United States through several prominent cases at the Beckett Fund. Ms. Uddin is also the founder and editor-in-chief of altmuslima.com, a web magazine dedicated to issues on gender and Islam. Her work at altmuslima.com has earned the praise of many, including Robert George of Princeton University, who has said, quote, "On matters of sexual morality, marriage, and family in Islam, particularly in the American context, I recommend the writings of two exceptionally gifted young Muslim women writers, Susie Ismail and Asma Uddin," end quote. The Huffington Post senior religion editor noted, quote, "Altmuslima.com is important because it gives a specific platform to the intersections between gender, belief, and well-being in Islam, all with superior levels of intellect and writing. The internet would be poorer without Altmuslima as a destination and font of knowledge for seekers of all religious backgrounds," end quote. She speaks and publishes widely on issues of gender and faith and national and international religious freedom. And the title of our conversation today is taken from an article, the same title for which she authored for our spring issue of the Review of Faith and International Affairs. Before we begin, I want to take a few seconds to provide a brief description of today's call format. We will start with approximately 20 minutes of commentary from Asma, followed by 40 minutes of questions from the audience. For the duration of the call, all participant lines will be placed on mute. If at any point during the call you have a question for Asma, please press 5* and you will be placed in the queue. So, with that introduction, let's turn to our call. Asma, I will turn it over to you.
Great. Thank you so much for having me, and many thanks to the listeners who have joined us today. I'm going to delve into the topic by focusing on Indonesia as an example. My work there is what planted the seed for the issue we explored in the spring 2015 issue of the Review of Faith and International Affairs. It made clear to me that effective advocacy requires that we fully explore the limitations language in international law and the way that language is interpreted in different legal systems. After talking about Indonesia, I'll back up a bit and tell you about some of the articles we featured in the journal, including the ones that revealed some surprises. On April 19, 2010, I was present when the Indonesian Constitutional Court issued its 8-1 decision upholding the country's law on the prevention of blasphemy and abuse of religion, also known as the Blasphemy Act. The legal decision confirming the legitimacy of blasphemy regulations and prosecutions was deeply disappointing for a modern democratic society such as Indonesia, the largest Muslim-majority nation in the world. The decision marked a major setback for the freedom of religion and expression in Indonesia. The meaning of those concepts, religious freedom and free speech, are hotly contested today. Some suggest they are compatible with the criminalizing of expression that insults religion or offends religious sensibilities, even when that expression does not incite imminent violence. Such views often seek to limit free speech in the name of public order or protect religious sensibilities in the name of human rights. The deeply problematic nature of such views, based on the subjective and ill-defined legal formulae, is evidenced in the increasingly absurd effects the Blasphemy Act has had on Indonesian citizens. For example, in 2006, Muhammad Usman was sentenced to 2 years in prison merely for reciting Muslim prayers in the Indonesian language instead of Arabic. In 2007, Sumardi Tapaya was sentenced 6 months in prison for deviancy after a relative accused him of whistling during prayers. Under the Blasphemy Act and related regulations, the government has also targeted minority religious groups, even those who consider themselves Muslims. Targeting such Muslims has the chilling effect of significantly narrowing, in both cultural and legal terms, the range of legitimate religious expression. In 2008, for example, the Attorney General and the Minister of the Interior issued a joint ministerial decree prohibiting the Ahmadiyya Muslim community from promulgating its beliefs. 3 years later, the government issued at least eight new local regulations similarly prohibiting the Ahmadiyya community from exercising even limited religious rights, such as communally gathering for public worship. More recently, Alexander An, an atheist, was sentenced to 2.5 years in jail and a fine of $11,000 for insulting his Prophet Muhammad. An's crime was posting a cartoon titled, quote, "The Prophet Muhammad had been sleeping with his wife's maid," and denying the existence of God on the Facebook page he moderated for atheists. An's status update also included a version of the standard atheist refrain, quote, "If you believe in God, then please show him to me," end quote. Such incidents are not isolated. Over 150 people have been detained merely for speaking critically about religion without any incitement to violence. What compels a government to imprison the Ahmadiyya merely for stating their beliefs, or to prosecute a man for whistling during his prayer? Are these restrictions results of the state cowing to extremist forces, or do they reflect the popular will? Exactly who or what is actually being protected? In recent decades, Indonesia has been on the path to democratization. Yet during that same time period has also seen an increasing number of blasphemy convictions. Why? Through my work as legal counsel at the Beckett Fund for Religious Liberty, a nonprofit law firm, I have encountered the many pernicious effects of blasphemy laws from Africa to Southeast Asia. The firm has advocated against such laws in several countries, and my work on these initiatives has disclosed severe infringements on freedoms of religion and expression. Moreover, state regulations on religion, such as blasphemy laws, routinely lead to the politicization of religion as they mix religion with matters of national security and public order. For example, in Pakistan, the abuse endemic to its blasphemy laws stems from both government and mob action. The law's language invites such abuse, being vague and expansive in punishing mere sounds, gestures, placement of objects, and indirect defamation, in addition to written and spoken words. Blasphemy offenses are punishable by fines, imprisonment, or death. Blasphemy laws in Pakistan have led to the routine persecution of the Ahmadiyya community in particular, a plight they have faced since 1953. It is the only minority religious group referred to by name in the more recently enacted blasphemy laws. Like Pakistan, Indonesia imposes severe restrictions on the Ahmadiyya community, as evidenced by the 2008 government-issued decree, which violates the sect's religious freedom. This decree was a product of a culture of fear created, perpetuated, and legitimized by the Blasphemy Act. The Act enables and encourages such persecutory measures by inviting the violation of religious freedom and free speech in the name of preventing so-called religious defamation, that is, the expression of denigrating language about religion. The folks who push for these sorts of blasphemy laws often argue that they are balancing free speech with the need to respect religion and religious persons, but the actual effects of such policies are always discriminatory. The Blasphemy Act doesn't promote respect, it promotes religious intolerance, which has devastating effects on dissenters and religious minorities. The intolerance also gets in the way of building a democratic culture guided by pluralist values and respect for different faiths. As such, when the opportunity arose to work on the repeal of the Act, the first time it would be challenged, I hoped that the Indonesian Constitutional Court would see the Act for what it truly is. Not only an unconstitutional infringement of a citizen's right to freedom of expression, religion, and conscience, which are bad enough in itself, but also more broadly an oft-accepted invitation to the harassment and abuse of minority religious groups. The day the court announced its decision was one of anticipation at the prospect that Indonesia would finally embrace more robust understandings of these freedoms for its diverse people and their developing democratic society. Such hopes, however, were dashed. The court upheld the Blasphemy Act. In addressing Indonesia's obligations under international law, the court asserted that, quote, the respect of the state towards various conventions and other international law instruments shall be in compliance with state philosophy and constitution of Indonesia. This statement reflects the court's overall approach throughout its opinion of contrasting Indonesian and Western rule of law principles. The court used the U.S. as a point of contrast to illustrate that apparently, unlike America, Indonesia is not a mis-atheist country. For example, it asserted incorrectly that the U.S. Constitution bars the teaching of religion in public schools, whereas in Indonesian schools, adherence to Pancasila makes religious studies mandatory. Moreover, in the court's view, Indonesia and America are different because Indonesian society values the belief in God and does not have space for atheism. As the court made clear, Indonesia would never allow campaigns on freedom from religion and freedom to anti-religion. The court also said Indonesia was different because, quote, the rule of law principle upheld by Indonesia is one of a law-based state that enshrines the principle of belief in one God as the main principle, not a state that separates religion and the state and not merely based on individualistic principles, end quote. Even though it painted the stark contrast, the court tried to prove that the Blasphemy Act is legitimate within the framework of international law. The court invoked the International Covenant on Civil and Political Rights, Article 19, Paragraph 3, which includes a provision that the right to freedom of religion shall also be conducted with responsibilities. The court also relied on ICCPR Article 18, which states that religious freedom may be subject only to such limitations as are prescribed by law and are necessary to protect public safety, order, health, or morals, or the fundamental rights and freedoms of others. The court held that these limits justified the Blasphemy Act's state-backed censure of religious interpretations that, quote, could trigger reactions that threaten security and public order if they are expressed or practiced in public, end quote. In other words, the government could limit blasphemous statements, including a simple statement of belief, as a way of preserving public order. The court struck a similar tone with regard to the Indonesian constitution. According to the court, the constitution was a product of a compromise among two schools of thought. The principle of a secular state was declined as well as an Islamic state, the court said. But the Constitution reflects an agreement that the state shall be based upon the belief in the one and only God. As such, in the name of freedom, no individual or group shall be allowed to undermine the spiritual level of the society that has been inherited as the values that constitute various laws and regulations in Indonesia. Claiming that the Constitution's mutual agreement among the Indonesian people rejects the concept of religion as merely a private matter, the court explained a limitation shall not always be interpreted as discrimination. In fact, if a limitation is aimed at protecting other people's rights and applied in the orderly life of the state, it shall be regarded as a protection of other people's human rights and as a protection of Indonesian people's cultural and religious identities. These last points are key. In upholding the Blasphemy Act, the court indicated it was respecting identities and protecting human rights. However, especially in keeping with its earlier contrast between Indonesia and the West, it makes clear that it defines human rights differently than the West. For one, in Indonesia, there's greater emphasis on communal rights as opposed to individual rights. Individual rights cannot trump the rights of a larger group. Moreover, the rights in question are not the right to choose or change one's religion or freely to express oneself in the public square. Rather, the language of human rights is used in this context to mean a supposed right not to be offended or insulted in one's religious sensibilities, as if those sensibilities are a kind of property the law protects against trespass. To define human rights in this way means criminalizing not only the intentional mocking or ridiculing of religion, but also genuine doctrinal disagreement. To be an Ahmadiyya Muslim in this context is to violate the rights of other Muslims regardless of how respectfully one expresses one's views. To express Ahmadiyya beliefs, in other words, is to violate human rights. By describing the Blasphemy Act as within human rights norms, the Indonesian court thus used the language of human rights to put severe limits on the freedoms of religion and expression. Such use renders genuine dialogue extremely difficult, as the language of human rights becomes more an ideological tool than a meaningful standard. Such a reading of human rights is all the more problematic, given that after defending the Blasphemy Act on international law and constitutional grounds, the court conceded that the law has been applied in problematic ways. The court viewed the abuses endemic to the act, however, as simply incidental, stemming merely from a problematic application of the law, which didn't require that the law itself be repealed. The court feared that repealing the act without first enacting a better substitute would lead to, quote, horizontal conflicts, anarchism, and religious misuse in the society. The irony is that this type of vigilantism and disruptions to public order the court sought to avoid were already occurring under the guise of the Blasphemy Act it upheld. As Jonathan Fox explains in the spring issue of the review, there is no empirical evidence that suggests that free speech and religious freedom are drivers of public disorder or public immorality. In fact, if you look at the impact of free speech on transparency and conflict, the evidence shows that free speech and religious freedom have positive socio-political effects on public order and public morality. There are numerous problems with the Indonesian court's reasoning, foremost among them that it fails to properly understand Indonesia's obligations under international law. Indonesia is a signatory to the ICCPR and the Universal Declaration of Human Rights, and has further outlined its commitment to these international instruments in its Human Rights Act of 1999. The HRA goes on to acknowledge that these instruments are legally binding in Indonesia. Indonesia also ratified the ICCPR in 2006 without reservations, and in doing so, pledged to protect the complementary freedoms of expression, association, and equal protection for both religious majorities and minorities. While the ICCPR states that these rights may be subject to certain restrictions, it notes that these shall only be such as are provided by law and are necessary. Though the concept of necessity is potentially vague, it at least suggests that the least intrusive means of achieving the allowable restrictions. Yet the court's interpretation of these limits broadens their scope to the point where the limits threaten to swallow the rights themselves. As Elizabeth Cassidy explains in her essay, limitations cannot be used to destroy guaranteed rights. The Indonesian Attorney General's authority to prosecute expression which might potentially endanger people and country far exceeds the ICCPR's public order exceptions. The word potentially itself is an open-ended invitation to prosecutorial discretion. Moreover, linguistically, public order encompasses far less than the court held it did. For example, the French version of the ICCPR helps make clear that religious freedom can be limited only by concrete violent disturbances posing imminent safety threats. This conception of public order is at the heart of the incitement to violence standard in U.S. free speech jurisprudence. American law on this issue helps explain what is a real threat to public order. For example, in Brandenburg v. Ohio, the U.S. Supreme Court held that the government can punish inflammatory speech if and only if said speech is not only directed to inciting, but likely to incite imminent lawless action. Under this standard, even laws that target generalized advocacy of violence are struck down as overly broad. In Noto v. U.S., the court confirmed that the mere abstract teaching of the moral propriety or even moral necessity for resort to force and violence is not the same as preparing a group for violent action and steeling it to such action. Even with such stringent standards, the U.S. court consistently recognizes that the public order argument is easily misused and cautions strongly against limitations on speech. In stark contrast, the Indonesian Constitutional Court construed ICCPR's public order limit as merely referring to general public sentiment, which makes the limit notably more subjective and vastly more prohibitive of speech and expression. The court's opinion in the Bosniaks Case planted the seed for the topic explored in this issue of the Review of Faith and International Affairs. Standing there in the courtroom, listening to the court's reasoning, I realized we had totally missed the mark in our advocacy. We were arguing that the act violated the international law on speech and religious liberty. We were focusing on the right, not the exceptions to the right. And yet, that's precisely where the court was focusing, and that is where advocates need to do more work. How are the exceptions interpreted and applied? How can countries purport to comply with international human rights even as they blatantly violate them? These were some of the questions that we touched on during my 2013 working group at the U.S. Islamic World Forum in Doha, Qatar. Some of the participants of that working group, along with other scholars and practitioners, were then recruited to write more detailed pieces on the topic for the current issue of the review. Working group participant Marshall Brieger, for instance, wrote a great piece on how the public order exception in American law is used interchangeably with the public policy exception. He explained the use of this public policy exception in terms of the recent wave of anti-Sharia laws. He predicts that even in the American context, the concept will be broadened so that it may eventually serve to create a, quote, right to feel welcome. Another working group participant, Reem Sarah Alawain, also talks about the broadening of the public order exception, but in the French, not American context. In her piece, Alawain explains how the public order exception has evolved at a particularly accelerated pace in response to the public expression of Islam. She writes, The end result of such a metamorphosis is such that public order has become a subjective value that could be used to restrict certain forms of religious practices. Within this new paradigm, public order morphed into a super-civil liberty, a core value used to limit other civil liberties, and more specifically, freedom of religion. These trends are no doubt troubling and underscore the necessity of exploring the exceptions to free speech and religious liberty law for more effective advocacy. Thank you.
Thank you, Asma, for that great introduction. We'll now open the lines for caller questions. As a reminder, if you would like to ask a question, please press 5 star. When it is your turn to ask your question, the call administrator will announce your name and unmute your lines so that you may ask it. Lines will be placed on mute following the asking of a question. If your question has been asked or you no longer wish to ask your question, please press 5 star again, and your name will be erased from the queue. For the sake of other callers, I will ask that when you are called upon, please immediately ask your question rather than providing your own commentary.
Okay, our first question is from Sarah Cornelison. Ms. Cornelison, go ahead and state your question.
Thank you. I was very interested in what you said about how the interpretation of public order and human rights differs across different countries. And I wondered in your research and in your advocacy if you found that there's a movement to define these terms or create international standards for interpreting these terms. Thank you.
Well, I mean, there's been a lot of discussion about this at the international level, and that's something that Elizabeth Cassidy discusses in her piece. But what she focuses on is really how at the international level there's a move to clarify the proper interpretation of the terms. And so most of the movement I'm seeing is more in the domestic context with a clarifying role at the international level. And the types of, and when I mentioned both the American and the French context, it shows that Indonesia and even Pakistan is not alone in their sort of domestic interpretations of public order as something much more expansive than the way it's being defined at the international level.
Great, thank you. Our next question is from Mr. Brian McGraw. Mr. McGraw, please go ahead and state your question.
Yeah, I was just wondering, with the ways in which the public order. Oh, sorry. I was just wondering, with the ways in which the public morality and public order standards have been used, what's the comparison that you might or might not be able to draw with various kinds of hate speech restrictions that are in place in any number of European democracies, and even in Canada? I mean, are there similarities that run there or not?
There is. I mean, so Marshall Brieger gets into this as well as Jacob Kangama. But as Brieger explained, the public policy exception is used to create essentially the right to feel welcome or the right not to feel offended. The interchangeable use of public policy suggests that if this is what society deems as essential to the proper conception of individual rights, then other fundamental rights such as religious expression might run counter to that, can be limited as a way of balancing it against this idea of right to not be offended. And so in that sort of anti-vilification, hate speech context, that's the way that it works. This idea is a competing right by members of, for instance, minority groups to feel welcome. And that's the way that the public order aspect fits in.
Okay, thank you. The next question is from Ms. Courtney Broad. Ms. Broad, please go ahead and ask your question.
Hi, thank you so much for your presentation. I think it's just very fascinating to these issues of concerning blasphemy, and I would like to know what are some other surprising findings in your research and in the scholarship in this field that you might have. Thank you.
Well, I mean, something that the last questioner raised, it's really the types of findings that both Marshall and even Reem brought up in their articles that I found very surprising, because this idea of the morphing of public order and public policy into new subjective notions. In some ways, the way that Indonesia, for example, misconstrued the public order exception is a bit predictable. This idea that we're kind of mistaking the relevant actor in this picture. That's not so much the person who's actually speaking, but the person who's being offended and then reacting in a violent way. And so that confusion of the relevant actors in the proper scheme of public order and incitement to imminent violence is a little bit more predictable than what we're seeing in these other contexts, because now you're making the concept increasingly subjective and developing and broadening it in ways that are definitely beginning to swallow larger and larger spaces of speech. I mean, if you consider, for example, with the French burqa ban and the way that the European Court of Human Rights, and this could in some ways also go to the first questioner's question about more of an international movement or multinational movement. But this idea, when the court decided that it was okay for France to ban the burqa, it went to this issue of the rights of others and the right to live in a society free from sort of the need to deal with symbols that are offensive to one. And that's just a conception of, again, public order and public policy that is incredibly broad. And there's a number of other domestic examples in the French context that give some further explanation to that, and further examples to the way that public order is now being defined in ways that were previously never envisioned. Even in the concept of, the concept of laïcité, like there's expansions even that concept to begin to that incorporate elements of public order, or supposed concerns about public order, that we can't have women in burqas, or we can't have students wearing conspicuous religious symbols because that's somehow threatening the order in public schools and imposing some sort of proselytism. And so those sorts of expansions are really the most troubling development in this space, and for me, were some of the more surprising findings.
Okay, thank you. The next question is from Ms. Jean Wu. Ms. Wu, please go ahead and state your question.
Hi, thank you for your presentation. Since you spoke about blasphemy, and this might be a little not directly related, but so I was wondering, since some people argued that Charlie Hebdo's cartoon and also the Mohammed cartoon event in Texas, they are blasphemies themselves, while the other fight for freedom of speech and expression. I'm just wondering, it would be interesting to hear about your views on these events. Thank you.
They're deeply troubling, but there are a few, recent manifestations of an ongoing issue. The blasphemy, the question of blasphemy laws is also related to a previous international attempt to outlaw what was called defamation of religion, and it was a resolution that was put out by the Organization of Islamic Conference it was a resolution saying that these sorts of defamatory statements should be illegal. And while the resolution itself didn't have legal effect, the idea was that eventually it would encourage or compel states to enact legal measures against so-called defamatory speech. And a lot of the critics of this resolution said that this essentially provided international cover for domestic blasphemy laws. But interestingly, that resolution was very much sort of came about from a series of the types of things that we see again repeated in Charlie Hebdo and other recent anti-Muslim controversies, in the sense that it was Theo Van Gogh's movie Submission and his subsequent murder, and the Danish cartoons, and the statements by Geert Wilders and so on, that those are the sorts of concerns that led to this international resolution, which has since been replaced. It's been replaced by something much more protective of free speech. It's a Resolution 1618, and there's a lot of work going on at the international level to maintain this new standard that essentially says, instead of legal limits on speech, that we instead focus on educational and media initiatives to help curb speech that may be considered offensive to others. And so, in response to your question, I would say that is part and parcel of the whole thing. It's something that has inspired international action in the past, and is precisely the sorts of things that a lot of these societies that have blasphemy acts on the books are trying to avoid. They see the violent repercussions of people being offended, and they, instead of focusing on, punishing those violent actors and creating order that way, they think the better way is just to prevent that disorder from ever happening, and therefore by silencing the nonviolent speaker.
Okay, thank you. Next question is from Ms. Yen Wu. Ms. Wu, please go ahead and ask your question.
Okay, thank you so much for your presentation. I actually have two questions. My first question is that what are your recommendations to lawmakers so that they can kind of work on a rule of law that can balance between public order and religious freedom? Because we know that, yes, religious freedom must be observed, but people cannot use religious freedom to create, bad public order. So how to balance it? My second question is that can you explain the use of public order exception in the U.S. law?
Yes. So the first question, a part of the question of how to balance those two, how to balance public order and religious freedom really goes to what I was saying earlier about this idea of understanding the causes of public disorder and what actually works to effectively create that order. And that's something that, for instance, Jonathan Fox gets into in his study of empirical evidence. So it's not enough for societies to say that preventing offense is going to create greater order. There has to be some sort of, there should be some sort of pushback against that, and showing that the evidence actually speaks otherwise, that the more restrictive the society, the greater the disorder. And it's even instinctually that can make sense, because if people are not allowed to speak freely in society, in open space, it doesn't mean that that speech is going to go away, right? It's going to be driven underground and in many ways mutate into more extremist forms. And so, look at the actual empirical evidence of what creates greater order and take that into consideration in determining the balance between the two. And also, to that point, what I was saying earlier about one thing that has been shown to create greater order is to actually go after and punish the violent actors. And every country that we're, in the world, and specifically the ones that we're talking about, have laws on the books that punish, for instance, arson or battery, assault, murder. And those are the types of laws that need greater enforcement. And that's definitely an initiative that's also part of the recommendations under Resolution 1618. They begin to focus on more effective means of creating order instead of using this front of religious freedom and religious sensibility as a way of supposedly protecting that. And then, of course, there's international law itself actually provides plenty of guidance on this point. For example, showing the limitations on religious freedom as justified under public order should be shown to be necessary, to be proportional. And so it's not that there's a confusion, that there's lack of guidance on this issue. It's really just a misinterpretation, and in many ways probably an intentional abuse of the public order exception that comes into play here. And so it's really looking at that guidance and beginning to more critically analyze whether or not one's laws are in compliance with that guidance. And in terms of the public order exception in the U.S., there's a couple of different ways. The one was the way that Marshall Brieger got into in the way that it's used interchangeably with the public policy exception. One of the examples he gets into is the way that this has come up in the context of anti-Sharia laws, and specifically the way that works there. There's more than 30 states at this point that have proposed, in some cases enacted anti-Sharia legislation. As he also explains in his piece, the type of laws that create a lot of additional problems while not really solving anything and being mostly sort of rhetorical flourish. And the reason for that is because in the case of religious arbitration, when it comes to a civil court actually enforcing the decisions from the arbitration decision, the court has to first check for instance, substantive and procedural due process, whether or not the person involved was there voluntarily, whether the right procedural measures were in place, and so on. And one of the other checks and balances there is whether or not the actual arbitral award or decision fits with U.S. public policy. And so that's the way the public policy, the public order exception comes into play. It comes into play in the form of the public policy exception. And the other way is when I was talking about Brandenburg and Noto and U.S. free speech jurisprudence in the incitement to imminent violence exception to free speech. That's the way, the very sort of narrow conception of public order, which is in fact the way that the international law provides guidance and sort of points to that same type of narrow interpretation of the exception. And so in U.S. law, it's interpreted in terms of incitement to imminent lawless action exception, which basically says that it needs to be imminent. There needs to be a direct connection, temporally, between the speaker and the violent action.
I'm curious. I just want to jump in here and ask maybe one of my own questions. We've talked a little bit about some of the legal strategies, about some of the ways that some of these international conventions have been applied to different countries around the world or not applied in different ways. But I see, and I'm particularly interested in some of the editorial work that you've done with Alt Muslim on some of the web editing. Are there strategies that you think are particularly successful that aren't necessarily legal strategies that can address some of these issues around blasphemy and apostasy laws? And I wonder, I guess that's the first part. The second part is I wonder if you could reflect a little bit on what your experience with that has been.
So in terms of, it kind of goes back to what 1618 is trying to accomplish, and saying that these are, for instance, speech like this is not a good thing, but it shouldn't be limited legally, but it should be sort of addressed through education and through media and so on. And so I think, my work in the space of Alt Muslimah and other work outside the legal space does precisely that. It tries to create a place where there could be robust discussion of these issues, where bad speech could be countered with good speech, and where members of the community itself, if you're talking about specifically anti-Muslim speech, but it's obviously scalable and applicable to other communities, can begin to counter some of that speech with clarifications and further discussion about Islam and Muslims. So again, it goes into countering bad speech with good speech, and so there's a robust space for action and contributions by society at large, and over the long term is a more effective tactic actually in pushing back against problematic speech, because it helps the society to grow in a really sort of substantive way, instead of the government basically infantilizing society and saying that we'll tell you how to behave, we'll tell you what is the proper thing or the proper things to say. It's essentially giving the responsibility over to social actors and saying, society, you need to learn to regulate yourself and you need to learn to overcome your own biases. So let me know if that's what you're getting at.
Yeah, absolutely. And I'm wondering, is there an example in particular that you've either experienced or worked on that you saw particular fruit in, just by way of a sort of, this is a way in which some of these conversations, which some of the stuff that's a bit more maybe upstream than legal conversations has borne fruit, and what that would look like?
Yeah, absolutely. So Alt Muslimah, which is the web magazine that I run, is focused on gender and Islam. And the way that came about was growing up as a Muslim female in America. I realized time and again that gender is essentially at the center of the majority of misinterpretations of Islam and Muslims, in the sense that when non-Muslims who don't know much about Islam think about Islam, what they think of are those media images of the quote-unquote oppressed or submissive Muslim women, women in burqas being beaten by the Taliban, polygamy and honor killings and harems and all these like horrible, sensationalized things that we hear about all the time that tend to drown out the actual lived realities for millions upon millions of Muslims around the world, including Muslims in America. And so I wanted to complicate that image a bit by offering a very public platform where Muslim women primarily, but also Muslim men, come to the space to talk about gender issues within the Muslim community and Islam in a very meaningful, thoughtful, and sometimes intellectual way that shows that there's so much diversity, so much complexity there, and that it's not black and white, and that what you see in the media isn't actually an accurate depiction of what goes on in the community. And so that's actually why it's called Alt Muslima. ALT is, it's essentially a web magazine that serves to provide an alternative, and I feel much more authentic representation of the community.
I'm curious, particularly because I've had some of these conversations about interreligious dialogue on some of these issues, and aside from actual political work, which is sort of necessarily interreligious, I suppose this is maybe a difficult question to answer straight up, but is there a role for what's your enthusiasm for interreligious dialogue across national boundaries on some of these issues? So, for example, I mean, there's Muslims in the United States having conversations as Muslims in the United States, or Christians in the United States having conversations with Christians in the United States, and then how would those sort of transpose to a place like, say, having conversations with Christians in the United States and Christians in Uganda, or Muslims in the United States and Muslims in Indonesia or Pakistan? What's your sort of level of enthusiasm for that in terms of as a change agent? What's your experience with that been?
Well, I mean, first on the question of interreligious dialogue, I'll start with within the U.S., because one of the things that Alt Muslim Guidance also has an interfaith component, it's a separate web magazine called Alt Fem, where we bring women of all different faiths. And that grew out of a space where the reactions and responses to a lot of our articles on the Muslim site were by Christians and Catholics and Jews, evangelicals and Catholics, telling us that many of the things that we were discussing were actually happening, or they were experiencing verbatim in their own communities. And so we realized, A, that many of our experiences are shared, and B, that even when it comes to media representations, a lot of other religious groups are really frustrated with the way their religious community, and specifically their religious community's perspectives on gender and sexuality issues are portrayed, misrepresented in the media. So I've definitely actively engaged in that in terms of U.S. interreligious dialogue. And for international, my experiences there thus far have really been my sort of serving as an ambassador of sorts and going to different, to speaking to members of Muslim communities in other countries and I've talked about issues of religious freedom and free speech with these other communities and explained the experience of American Muslims. So there's the American Muslim and dialogue happening with Muslims abroad that I've actively participated in. And I think while I haven't to date participated extensively in interreligious dialogue across national boundaries, I definitely think that that is an important space to further develop. And I know that IGE is really at the center of a lot of that work. Because it's again about how going back to the idea of like just their experience of religion, and this is what undergirds most of my work at the Beckett Fund, this idea that religious experience and the way that we live out our faith in public is an experience that people of all faiths value, and that it's something that needs to be protected on behalf of people of all faiths. And so sharing those experiences of how we experience of the way that those rights are protected or not protected in different national contexts is something that it'd be great to have at the fore of interreligious dialogue. just understanding the experiences, the diverse experiences, the ways that the American experience can begin to shed light, for instance, on the experiences of faith and religious practice in more oppressive societies. I mean, I think there's a lot there that could lead to change. But I myself have not actually participated in the cross-national interreligious space.
I mean, that opens up a couple of personal questions I'm interested in as well. I mean, you're doing some fascinating, I mean, difficult work in many respects. I'm curious, especially for people who might be on the call, students and others, people that I know I see in the classroom. How did you get engaged in this sort of work? I mean, what's the sort of root of your passion for this work, and what was the journey to get there?
So it was the journey began when I was in middle school, and I had a deep, at times very naive sort of understanding of religion as a force for good, and it could be nothing else. And while that rather warm and fuzzy perception of religion was complicated in the years to come, especially in the years after 9/11, I ultimately stayed true to the idea that religion is a source of incredible good, both for individuals and for communities, for the broad society, and for the world. And the protection of that religious impulse, especially in the public space, is something that's critical for positive, for having a robust and healthy society. And when I went to law school, naturally the next step would be really what are the ways that religion, the law can help protect that vibrant public expression of religion. And so while there were many twists and turns in my journey, eventually I did find myself at the Beckett Fund because I knew that in terms of devoting my life to a specific area of civil rights and civil liberties, that it was specifically that ability to practice your faith, largely free from government restrictions, that I want to devote my career to. And it's always, I work both in the domestic space in the U.S. context and internationally. And in the U.S. context, we're fortunate that many of our struggles and legal battles here are much more nuanced, really get into the sort of deeper questions of, for instance, religious autonomy and religious expression. But abroad, unfortunately, most of those questions are still at very much a life and death stage, where people can't even profess their beliefs. A simple statement of belief, for instance, and as I was talking about in the Indonesian context, is seen as somehow subversive to public order. And people, the Pakistani blasphemy laws punish blasphemous statements, which it says could be anything by, gestures or innuendos or placement of objects or sounds. I mean, it's like the most overbroad statute, and yet the punishment that comes with it is life imprisonment or death. And so it's just seeing that sort of basic idea that I just knew instinctually ever since I was a kid and grew up with and decided to spend my life defending is something that is just, it's a basic understanding that is not even understood. Doesn't even exist in legal and social contexts in many countries across the world.
Thank you. Yeah, that's very interesting. That hits home for me as well. Actually, just as a follow-up, I'm curious about this transition from having a vague feeling that religion is fuzzy and good to enlisting it or thinking about it in a kind of productive democratic way. I'm interested in how that happened, how that transition happened. I think a lot of people who will be on this call or do this work with people who are sort of aware that religion can be a good thing, but it's also a kind of dangerous and kind of a scary thing. I wonder, especially in sort of post 9/11 world, what some of that looked like in terms of how you negotiated and maybe how you came to think about it more specifically along the way, especially in the field of law.
Well, I mean, it first started off in a very non-legal way. So I went from this very simple understanding of religion, and then when I entered college, so it's actually all rooted in the journey that also led to Muslim law. In that, when I started college, I decided that was the point at which I was going to start wearing the headscarf, And that automatically made me very publicly visible as a Muslim. But it also then kind of put me right in the space of publicly negotiating a lot of what it means to be an American Muslim or a Muslim female. And being in the college context, all of a sudden you're hit with all this like diversity, including people from across the U.S. and even across the world. In particular, my school had a lot of foreign male students from Saudi Arabia who decided to come study at the engineering school there, and participating in the Muslim Students Association, which at that time at my university, actually, we had two of them. One that was run by these foreign students, in which it was largely all male, and women, if they participated, were to speak from behind a barrier, and they were to never assume a leadership role. Whereas the American Muslim Association was quite different, in which women were the leaders, women were quite outspoken, and those women were, whether or not they wore a headscarf. And it was just this stark contrast, which made it very clear to me that, and it might seem, something I should have picked up on earlier, and I did, but this was a really extreme sort of representation to me that religion has multiple interpretations, and some of them are not very good, or not something that I can really reconcile my own conception of Islam with. And that ended up resulting in quite a lot of anguished spiritual reflections. I started doing a lot of research. At the time, I was doing a lot of research on a classical Islamic scholar, Imam Ghazali, whose writings on every topic are amazing. But then when it came to the topic of women, and granted he is a product of 11th century patriarchal society, but a lot of his writings on women were essentially can be distilled to the idea that women are there to help facilitate the spirituality and religious practice of men. And so from all sides, and all of a sudden 9/11 happened, and the media went full on with justifying the war in Afghanistan with images of women in burqas. And so from both internally and on, within the community, on the college campus, in these classical texts, in the media, from every angle, I was being hit with this message that Islam somehow gives a lesser position to women. And it took me almost to the point of leaving my faith. But I just realized one day I just need to put it all away. I need to put away all the social commentary on faith and just reflect. And I reflected on the basic core Islamic understanding of our origins, our original disposition, which is called fitra. And I came to the realization, thinking about that and reading about those ideas, that God couldn't have created women as anything other than equal to men. And from there, I was able to pull myself back from the precipice between faith and non-faith. And it gave me the renewed energy to really grapple with my religion in a way that was concrete and based in real life and in my lived experiences. So I actually went full circle back to a very positive understanding of Islam, because it's about at the core it embraces equality in the way that it's been lived out in my own life, in terms of my own experiences with other Muslims, outside of this social commentary, and this idea that there are versions of Islam, that in fact that for a long time I was struggling with the idea that that somehow having these multiple interpretations of a religion somehow took away from the idea of absolute truth. And I kind of came full circle to this idea that in order for a faith to be true, it has to be able to be interpreted in a number of different ways in different cultural contexts, and that doesn't in any way take away from authenticity of any one of those interpretations, including the ones that I grew up holding in terms of the equality of men and women. So that's sort of a very truncated version of like the bigger story, but having a renewed interest in religion, I went on to, in both college, majoring in religious studies, and then in law school exploring religion and law in American context. And then even when I was working at a large corporate firm, taking on cases, specifically I worked on a case where I was a Muslim policewoman in the Philadelphia in the city of Philadelphia who wanted to wear a headscarf on the job and was not allowed to. And just saw my renewed interest in exploring these issues and now in the concrete circumstances of the American legal framework. And from there, found my way to the Beckett Fund.
Amazing. Thank you. We have time for one more question. James, I'll turn it back to you for the moment.
Okay. This next and final question is from Ms. Sharice Bukowski. Ms. Bukowski, please go ahead and ask your question.
Hi, thanks for being with us today. I am interested in how standards of proof enter this discussion in these different countries. Do we have something similar to beyond reasonable doubt or clear and convincing evidence, and how does that factor into this discussion?
So, for instance, in terms of, if I use the example, so I would say to start, a lot of the standards of proof are not something that are used in a number of these other domestic contexts. And it's not just the standards of proof, but so many other basic ideas are used in, for instance, American law and the canons of statutory construction. I mean, I was speaking earlier about the Pakistani blasphemy laws and how they're overly broad. How they also don't require mens rea or like criminal intent. And so, in addition to docking those standards of proof, there's also a lot of other really basic aspects of statutory construction that are completely missing from a lot of these highly speech restrictive laws in a number of these countries.
Thank you.
Thank you. And we are out of our time here, ladies and gentlemen. Thank you, Asma, in particular, for this engaging, this insightful conversation. Thank you to our callers for joining us today. I hope that you'll join us again on our next Facing International Affairs conference call on Thursday, June 25th. Susan Hayward, the director of the United States Institute of Peace, Religion, and Peace Building program, will be speaking on intolerance and inclusion in Myanmar. Thank you again to everybody for joining us, and have a wonderful day.